Welcome to School's Law. It's Salambo 2, and today we are going to be talking about 4 changes that the Contract Act of Ghana 1960 Act 25 has made to the doctrine of consideration as common law. There are 4 changes, but before we proceed, if you have not subscribed, kindly subscribe. If you have subscribed, please turn on the notifications button so that when we post new videos, you'll be notified. Now, the first change is to the principle at common law that a promise to keep an offer open is not binding until some consideration has been given for it. That is the principle at common law. But this has been changed by Section 8(1) of the Contract Act, which says that a promise to keep an offer open does not cease to be binding only for the reason that there was no consideration given for that promise. Now, at common law, a case that illustrates this principle is a case called Routledge versus Grant. And in that case, the defendant promised to sell his house to the claimant, and he said the offer was open for 6 weeks. But before the 6 weeks elapsed, he sold the house to another person, and when the claimant contacted him to effect the sale, he said that because there was no consideration given for his promise to keep the offer open for that 6 weeks, he sold it to another person. And this was affirmed by the court in application of the principle that at common law, if a person promises to keep an offer open for you for a period of time and you don't give consideration for that promise, it is not binding on the person, and he may choose to sell it to another person within that period, and there is nothing you can do about it. But like I said, that principle has been changed by Section 8(1). So under Section 8(1), even if no consideration was given for the promise to keep the offer open, it's still binding. And another change that has been made is to the principle that a promise to waive a debt or part of it is not binding until some consideration has been given in exchange for it. And a case that illustrates that is the case of Folks versus BA. In Folks versus BA, Folks owed BA some amount of money and he defaulted. So Folks obtained judgment against him to pay the money with interest. But then after that, the parties entered into an agreement where BA agreed that if Folks was able to pay £500 upfront and subsequently £250 monthly, she wasn't going to enforce the judgment against him. Now, he did that, and then subsequently she sued to claim the interest on the amount, okay? And he claimed that because she had promised not to enforce the judgment, then the interest as accrued to her by statute or under statute, she was not entitled to it because that was interest on the judgment debt. So if you promise not to enforce the judgment, you shouldn't be entitled to the interest on it. But the court did not agree with him. They held that she was entitled to the interest because her promise to waive the enforcement of the judgment debt was not supported by consideration from him. So then in that case, the lack of consideration being given by him to her meant that the promise to waive that part of the debt, the interest in this case, was not binding. And so she could recover it, even though she herself had promised not to, insist on it or, obtain. But this has been changed by the Contract Act at Section 8(2), which says that basically, even when consideration was not given to support the promise to waive the debt, the offeror is bound by the promise. So regardless of whether or not, under Ghanaian law, regardless of whether or not consideration was given to support a promise to waive a debt, that promise is binding, even though at common law it is not, as we've seen in Folks versus BA. Another change that has been made is by Section 9 of the Contract Act, which changes the rule at common law that when you are under a legal or contractual duty to do something, you cannot submit that thing as consideration for a promise. Now you can see an illustration of that in a case called Stilk versus Myrick. You can also read Collins versus Godefroy. Now in Stilk versus Myrick, the claimant worked for the defendant. He went with them to see, and then when he was employed, he promised to do anything in his power to assist his employer, Now, when they came back from one of such expeditions and the ship docked, 2 other workers deserted. Basically, they ran away. And so the amount of work that needed to be done increased. The defendant, the employer in this case, promised to pay the claimant extra if he did the work that the 2 other who had deserted were expected to do. He did it, and then the employer defaulted in paying him. Now, he claims that he should be entitled to the amount of money that his employer, promised. But the court said that in this case, he was already employed. He already had a contractual duty to do everything in his power to assist his employers in his line of work. So doing that is not enough it's not enough consideration to support the promise by his employers to pay him extra, right? Like I said, you can read the case of Collins versus Godefroy. But Section 9 changes this rule. It makes it possible for you to submit something you are under a contractual or a legal duty to do as consideration, to support a promise that has been made to you. And you can see the case of Kessie versus Sharmant, a Ghanaian case in which the court said that there was valid consideration in this case, even though the claimant was Ghana's ambassador and he was entitled to assist all Ghanaians in the country. He was an ambassador of Ghana too. The final change is by Section 10 of the Contract Act, which says that consideration may move from someone else other than the promisee. Now, under common law, consideration must necessarily move from the promisee. So if the offeror and the offeree, or the promissor and the promisee, the promissor makes the promise, and then the promisee is the one the promise is being made to. So he should give consideration in exchange for that promise. That is the rule at common law. And you can see cases like Tweddle and Atkinson, Dunlop versus Selfridge. But under Section 10 of the Contracts Act, consideration need not necessarily move from the promisee. It may move from someone else other than the promisee. These are the 4 changes that the Contracts Act 1960 has made to the doctrine of consideration as it exists under common law. This is where we end the video. I'll see you again in another video where we talk about promissory estoppel in contract law. See you another time.